Briefly, Sally Yates started her career as a civil litigation lawyer at King & Spalding. After just a few years, she was tapped up to join the Department of Justice, and that led to 27 years of being at the Department of Justice, working her way up through the ranks. And I have to say, what King & Spalding lost at that time, I think the United States gained. So in addition to being an assistant U.S. attorney, she was nominated by President Obama to be the U.S. Attorney for the Northern District of Georgia. She was the first woman to ever hold that position. She subsequently was nominated and then approved by the Senate, obviously, to be the Deputy Attorney General of the United States. During her time as DAG, you will have, of course, come across the individual accountability for corporate misconduct policy that was developed by the DOJ during that period of time, or otherwise sometimes referred to as the Yates Memorandum. And then finally, and more recently, she served as the acting Attorney General during the early days of the current administration. At all stages of her career, she has, fulfilled her duties as a lawyer with both passion and principle. And in doing so, she has become an inspiration not only to countless lawyers, I think also to many, many non-lawyers, and not only to Americans, but to people around the world. And so for that and for much more, I'm extremely proud and delighted that she has now come back home to King & Spalding as a partner, and that she's here with us today to give some remarks. So without further ado, I will hand the microphone to Sally Yates.
Thank you, Aaron, for that incredibly kind introduction. I have to tell you, I feel a little sheepish now. I realize that I am what is standing between you and lunch right now, which is not exactly a great place to be. But Aaron mentioned that I was at King & Spalding nearly 28 years ago, and it hasn't changed a bit, really, in that time. But actually, one of the great ways that it has changed is that when I left K&S, we had 2 offices and a couple of hundred lawyers. Now it's 20 offices and over 1,200 lawyers, and I have the great fortune of having colleagues like Aaron and others here in London, so it's been a real treat for me to get to know some of them. I also want to thank the Criminal Justice section of the ABA for inviting me to speak here today, and to our friends in London for hosting us here today. I'm particularly grateful to be invited to speak here today because I realized that recently, when you all have invited someone to visit in London and to speak, it hasn't necessarily worked out that well. And so just so our British friends are not nervous here, I thought that I should tell you, I am not going to insult your Prime Minister or your Mayor in this speech. I do know the difference between England and Great Britain and the United Kingdom. And if ever I had the privilege to meet your queen, I can assure you that I would not walk in front of her, nor would I keep her waiting on me. I took a look at the agenda for this conference, and it looks like you've got really an outstanding lineup, and obviously, just as we just heard, some really impressive speakers, really talking about the cutting-edge issues that are facing white-collar practitioners today. And I've been asked, as Aaron said, to talk a little bit about the individual accountability policy. And I know you all call it the Yates Memo. I can't tell you how that creeps me out, that it's called. And so I have a hard time letting that roll off my tongue as the Yates Memo. And I'm going to get to that. I know this is a white-collar conference, and so we're supposed to talk about white-collar things. But given that we are meeting here today, just 20 miles or so, I guess, from Runnymede, the birthplace of the rule of law, and given the importance of this cornerstone of democracy to countries all over the world, it seems appropriate that we would pause and reflect for just a minute about the importance of preserving the rule of law all around the world. And when I talk about the rule of law, I'm not referring to that hard-nosed, lock-em-up, law and order, no prosecutorial discretion kind of thing that some people call the rule of law. I'm talking about that really fundamental promise that no one is above the law and everyone is entitled to equal protection of the law. And we really have our British friends to thank for this, given that the rule of law has its roots in the Magna Carta signed over 800 years ago. And I know you're probably thinking right now, it doesn't sound like we're heading to sort of a light, breezy lunchtime speech when the speaker is invoking the Magna Carta. But I promise you, I'm going to link this up as we tell judges in trial sometimes. Who would have thought that the actions of a bunch of angry land barons who were just fed up with tyrannical King John back in 1215 would have any real relevance today? But when they rebelled and told the king through the Magna Carta, you can keep ruling, but you can only do that if you agree that you have to follow both the law and the customs, what we might call norms today. You have to follow the law and the customs. You, the king, are bound by that. And when they did that, they really set the world on a more just course. And from that, the rule of law has developed from the principle that not just no one is above the law, but also to include the principle that everyone is entitled to equal protection. And countries around the world have really implemented this in a variety of ways, but the hallmark of all liberal democracies is that the power of the state can't be used by the executive as a sword to go after one's enemies or as a shield to protect oneself or one's friends. That there's one system of justice that applies equally to everyone. Despite the fact that this concept is enshrined in our founding documents back in the States, despite that fact, we have struggled really as a country to fully live up to that promise of equal justice. At the time of our founding document, the Declaration of Independence, at the time it was penned declaring that all men are created equal, the United States enslaved hundreds of thousands of African Americans. Not so long ago, all across the Jim Crow South, our country's very definition was threatened by lynchings and burning buses of freedom riders and the systematic disenfranchisement of African American voters. And still today, racial disparities and unequal treatment of the poor haunts our criminal justice system. But despite these shortcomings, we have always remained committed to the principle, if not in our every deed, to equal application of the law. And it was this promise of one system of justice that motivated the individual accountability policy that we instituted back when I was DAG at DOJ. And unless you get the wrong idea, I want to be really clear right now, the Yates Memo is no Magna Carta. I'm not suggesting that. But rather what I'm saying is what inspired us to go back and take a look at how we were approaching corporate crime cases was our responsibility to ensure that we were doing everything that we could to determine whether or not there were culpable individuals responsible for corporate crime, and if there were, then to do everything we could to hold them accountable. It was our responsibility to make sure that we were enforcing the law regardless of whether that crime occurred on the street corner or in the corner office. And as you all may recall, this initiative followed complaints that were widely repeated that no one went to prison after the financial crisis. And regardless of the accuracy of that statement, it doesn't really matter whether it's accurate or not. The fact is that there was a perception that rich people who may be responsible for millions or even billions of dollars in losses are not being held accountable, while regular guys who commit less serious crimes are going to prison. So we decided at DOJ that we should step back and we should take a really hard look at how we were approaching corporate crime cases. And again, to make sure that we were doing everything that we could to root out any culpable individuals. So we do what you do in DC, which is we convened a working group. We brought together people for several months from all across the department, from U.S. attorneys' offices, from the components, from the investigative agencies, to take a really deep dive in how we were approaching these cases. And a few things became clear to us during that time. First, a fair number of corporate fraud cases really start as civil cases. And that's particularly the case in the financial institution cases that were civil FIREA cases. And normally, in a civil case, since very few individuals have pockets that are deep enough to be able to satisfy those judgments, normally in civil cases, the Department of Justice really investigates those cases with an eye toward the entity, the corporation. And so interviews are done and documents are reviewed with an eye toward corporate responsibility, not individual. Well, toward the end of Attorney General Holder's time, as sort of this drumbeat was beginning about no individuals going to prison, Attorney General Holder told everybody to go back and to look at those civil cases and try to figure out if there are culpable individuals there. And people worked really hard at that. It's not that there was a lack of will, I think, on the part of any lawyer at DOJ. They wanted to make those cases. But what we discovered is that when the cases had been investigated and the documents reviewed and all of the interviews done, just with an eye to looking at the corporate culpability and not toward trying to root out the actions of specific individuals, it was pretty much impossible to go back and unwind all of that. So one of the changes that we made was to insist and to issue a directive to the lawyers at the department that in both civil and criminal cases, that DOJ lawyers are to focus on individuals from the very beginning, and that the department lawyers should make decisions about whether to bring a civil case against an individual, not based solely on whether they had the financial ability to satisfy that judgment. That was one factor to be considered, but just one factor. They should also look at the seriousness of the wrongdoing and the individual's history, the amount of loss, where they were in the company, all of those other factors that you consider when you're looking at criminal cases. This is actually one of those things that hasn't gotten a lot of attention in connection with the individual accountability policy, but I think is actually one of the biggest changes that was made in that policy. The provision that did get the most attention and that's considered the most controversial, of course, is the all or nothing provision, the requirement that if a company wants any cooperation credit, any credit at all, that it has to provide facts about essentially who did what within the company. And so let me tell you just a little bit about what our thinking was on that. I mean, as you all know here, for quite some time before this policy, the department had been emphasizing that if a company wants cooperation credit, they need to provide that factual information about the actions of individuals. Lanny Brewer, when he was head of the criminal division, talked about it a lot. It was right there in the policy. Leslie Caldwell beat this thing to death. She was head of the criminal division after Lanny. Every speech she gave, just about, she was talking about this. But what we found is that while some defense counsel were heeding this and were coming in when they made presentations on behalf of their clients and providing that factual information about who did what, most were not. Most were still giving us what I'll call that passive voice, mistakes were made presentation that didn't really identify who made those mistakes. And they were still getting some element of cooperation credit for that, so it really wasn't worth it for them to go that next step. So we determined, and it wasn't just defense counsel, what we also found was that there was inconsistency at DOJ as well in terms of what prosecutors were requiring. For example, some U.S. attorneys' offices were very insistent that that wasn't good enough, that you needed to provide the information about who did what, and others were not. And that kind of inconsistency just isn't fair. It shouldn't be really based on the luck of the draw of who you happen to get as a prosecutor to be determining a decision quite that important. So we decided that we needed to get rid of the sliding scale and to make it an all or nothing proposition. A clear rule that if you don't want to give that information, you won't get any cooperation credit. And as you all know, and you probably are responsible for some of these, it set off a flurry of client alerts and law review articles and all sorts of other things and symposiums and all just like this. And I'll confess I didn't read every single client alert, but I did read a lot of them because we wanted to, the goal of this was to make sure we were clearly articulating what the policy was. And it seemed like the reaction sort of varied from either the sky is falling, you know, DOJ will never get cooperation again from a company, to this isn't really anything new. This is what people have been doing for a long time. And I think the truth is, as it often is, was somewhere in the middle between those two things. I will acknowledge to you that I think that this policy and this particular provision certainly makes internal investigations more complicated for the company and for defense counsel, particularly when it comes to the issue of representation. It makes it more complicated and more burdensome. But we made it clear at the time when we announced this policy that the goal here was not to require a company to, in Leslie Caldwell's words, to go out and boil the ocean, to take one allegation in one office and that means you have to do an internal investigation all across the globe, but rather to do an investigation that is tailored to the specific allegations of that case. Likewise, we tried to make it clear that it doesn't require a company to serve someone up to take the fall for the company. It's what Larry Thompson, my predecessor, a DAG before me, called the vice president in charge of going to prison. It doesn't require that, nor does it require a company to pen a scarlet letter on any of their employees and to say that this person is criminally culpable. Rather, what it required was a description of the facts of who did what. The final point that we tried to make that I think did get a bit lost is that, look, I think everybody recognizes that sometimes, despite all your best efforts, despite doing a reasonably tailored investigation, you just can't figure out who's really responsible for the bad thing that happened. And we also tried to make it clear in those circumstances, if the company has made a good faith effort at trying to root this out, that does not preclude them from getting credit for cooperation. The goal of this was never to generate any numbers or to call for any particular number of corporate heads. The goal of this, and while the policy is absolutely not perfect, but the goal of it was to try to ensure that DOJ, again, was doing everything it could to identify if there are culpable individuals and to hold them accountable if they are. The goal was, in short, to try to make good on the promise of one system of justice that applies equally regardless of anyone's socioeconomic status or the type of crime that they've committed. The goal was to try to get us just a little bit closer to that. Now, recognizing that we are just minutes away from lunch, I'd be happy to take any questions that you might have about any of this or any other topic, or if you're just plain hungry and want to get to lunch, well, thank you for really the honor of being able to be with you today. Yes?
A question about the series of memos that you started from the Philip memo after the KPMG case and the way that privilege was treated. Mm-hmm. And the department was criticized for insisting or asking for a waiver in the KPMG case. And since then, all these memos have drawn a distinction between what they call core attorney-client or work product effective. We don't want the lawyer's advice, but we do want all the facts. And then, mm-hmm. Your memo insisted on tell us the facts. But that seems to ally what is the core of the attorney-client privilege, which is facts provided by the client to the attorney for the purpose of eliciting legal advice. So isn't that kind of asking for a privilege waiver without explicitly doing that? And was that something that came up when you guys were coming up with the next generation of the Yates Memo?
Yeah, we certainly thought about that. And look, I think that is a fair concern that's been expressed about this. To the extent, though, that it's your perspective that asking for the facts here impinges on the attorney-client privilege, that didn't arise in connection with the individual accountability memo. That was the case even before this. So I think it's my view that there was no new step that was taken there. What we changed was the consequence of what happened if you didn't provide this information. We didn't really create a new obligation that was there. Like, I think it's a thorny thing to tease out the difference between information that is privileged versus facts that by themselves are not privileged. I can tell you that lawyers do it every day in the presentations that they make to DOJ and providing that factual information without effectuating a waiver. But I acknowledge to you it is a fine line to walk. Yes.
Well, now that you're on the other side and having to give Upjohn warnings before you interview, I mean, can you comment on the interplay between the individual policy and that process?
Yeah, and folks probably find it as some poetic justice, right? That now I'm on the other side of this and have to live with the monster that I created in this. And look, I've only been at this for 4 months now at King & Spalding, so I'm certainly not going to claim that I'm a pro on this. Yeah, look, I grant you that it does make it more complicated. I guess I expect you all were giving Upjohn warnings even before the individual accountability memo. I mean, lawyers that were doing their jobs were letting the clients know that you don't, or letting the employees know you don't represent them, and that if it is in the company's best interest to provide that information to the government, that you're going to do that. So now I think it is just perhaps there's a finer point on that there's a really good chance it's going to be in the company's interest to provide that information. So to me, it doesn't really change the Upjohn warning so much as it does, I guess you might say, magnify the importance of those warnings. And I think that's why you see companies more frequently getting separate counsel for individuals earlier in the process than they did before, to be able to advise the employees about whether it's in their interest then to provide this information and what their rights are vis-a-vis employment, et cetera. Yes, sir. Hi.
Thanks for doing this as well. Have you seen any shift in positions under the new administration? I think the current bag is still in place for financial.
I think he's good till after the midterms at least. So.
What's your view on the new administration and their shift from individual versus corporate responsibility?
You know, there have been a lot of policy changes in this Department of Justice, and I think, candidly, you have to expect that. Elections have consequences, and there are going to be policy changes. One area where you have not seen as many changes, though, is just generally in the white-collar area. Things like, for example, the no piling on policy. I think that's a really good thing that Rod underscored that. That's not new. I mean, that's always been the policy of the department. But I think it was absolutely time for an increased emphasis on that policy. Individual accountability, actually, you've seen them embrace repeatedly in speeches and otherwise. Now, look, might they revoke the policy or revise it? If there are ways to make it better, to make accomplishing this goal more effective, I'm all for them doing that. There's certainly no pride of authorship in this particular memo. But what you haven't seen, in fact, they've emphasized over and over, particularly as it relates to giving non-prosecution agreements to more companies, inverse then emphasis on prosecuting individuals. So it seems like that emphasis is here to stay, and it's beyond, or here to stay. And it's beyond just DOJ. I mean, you see it at SEC and CFTC. I mean, you see it sort of across the board, and not just in the States, but in other countries as well. So that would be my expectation. But look, I could be wrong. Anything else? Well, thank you all for having us today. Let's have lunch.